program today is designed to help you know about new changes and developments that affect your company's operations or your employees. This is a time when it's really important for HR personnel to keep up to date with what's going on because things are changing so rapidly and so much. Today, we're going to talk about HR 1319, which is the Biden Plan, American Rescue Plan Act of 2021. It has some immediate and direct impacts on many employers. We also talk about other COVID issues that developed, a new court decision that affects time rounding and meal periods and rest breaks and penalties. Talk briefly about a new development regarding the Private Attorney General's Act, or PAGA. Remind you about business expense reimbursement and talk about a few issues that are breaking at this time. So to start, the Biden bill is in effect. And one of the important things for employers is that it extended on a voluntary basis the FFCRA tax credits until December 30th, 2021. And the good news is this is a voluntary decision, unlike the original act in the middle of 2020. Employers can either use this process where they provide either emergency sick pay or even emergency FMLA pay to employees. And in California, because we have the Cal-OSHA emergency regulations that require employers to pay people who are not able to work due to a diagnosis from COVID that relates to work, not non-work items, whereas the FFCRA credit applies whether the source of the illness is work or non-work. But since you have to pay under California law for employees who get sick during work, why wouldn't you use the FFCRA effort? Because it's reimbursable to you. If you don't use this, you have to rely on a variety of other company and other state plans to pay the payment required under Cal-OSHA. And some of those options will not be reimbursable to you as a company. They may be tax deductible, but they will use your cash in the process. The only rule this time, other than being universal, is that other than it's voluntary, is if you decide to use this, you must be non-discriminatory and offer the FFCRA tax credit to all employees. That means all employees who obviously become ill and are quarantined or diagnosed with COVID and can't work. If employees had used some of this leave because there were 80 hours available starting in March of 2020, as of April 1st, they can start another set of 80 hours. That doesn't mean that you have unused time last year, say you used none, so you had 80 hours available from last year, and now you get 80 hours. That does not mean you accumulate and get 160 hours. The maximum benefit for emergency sick leave is still 80 hours. It also adds 2 new reasons to qualify for this leave, in addition to being diagnosed as positive or told by a medical provider that you must be quarantined and not able to work. And that is if it takes time to get an immunization related to COVID-19. Now, this is important because many employers are contemplating now whether to require or just to encourage immunization among their employees. But under the Cal-OSHA regulations, time spent during getting immunization or testing is reimbursable. So why not use the FFCRA and get reimbursed to their company the money that you spend on that benefit? It also covers any time recovering from injury related to immunization, which could be a day or two in most cases. I would say from everything I've heard, over 90% of the time, people may have fatigue or sore shoulder, I can claim proudly that I've had my second shot now and have been through that. But it's not usually many days involved. Now, one of the reasons you might say, why is all this important? Because we're on the downside of the COVID pandemic. Well, in California, almost 2,000 people every day now still are reported as having COVID. We have about 150 to 200 people in California who die every day because of COVID. So this is not over, although maybe we can see the light at the end of the tunnel. One of my friends and our teammate said, yes, the light at the end of the tunnel could be an oncoming railroad train coming right at you. One hopefully would say that in pandemic terms, the light at the end of the tunnel means that we hope that we'll be open up and have more freedom. The Act also provides enhanced unemployment benefits. And some of you are aware of this. It applies if the unemployment is caused by COVID, and provides at this time now an additional $300 a week to employees in addition to state benefits. It also assures that people will be able to receive unemployment benefits for up to 53 weeks after the initial 24 weeks of unemployment ends. So this is an important provision for those who had employees who have been laid off or had their jobs terminated. This will be administered by ADD, so employer action isn't necessary, but it's important to be aware of it. Another one, which is just becoming clear now, is the impact on employers where people have lost group health coverage due to COVID, which would mean the company terminated its operation or employees were quarantined or unable to work. The new federal law requires employers to pay the employee premium on COBRA. And it also includes not only people who have this from now on, but goes back to as early as November 2019 through March to determine if someone had qualified and is now eligible for employer reimbursement. Employers are to pay the COBRA premium for eligible employees starting April 1 through September 30th, 2021. But you will be reimbursed, just as under the FFCRA, by a credit on your payroll taxes. From employers, the most critical piece is they have to give notice to employees. So one of the questions is, did you have people who lost health coverage from March of 2020 until March of 2021? And did they need to have COBRA, and are they now eligible for the next 6 months for COBRA payments by the employer? So if an employee didn't elect COBRA last year when they lost their job because of the cost, they can now have a new period for election. They have 60 days after the date of you notifying them of this new change in federal law. So employers should look at their records to determine who lost health coverage last year or through March of this year, as well as be aware this applies for new. This is probably going to be one of the more burdensome issues for HR departments and company payroll departments. Some other provisions under the federal law are increasing independent care assistance and the expansion of the child care tax credit. And this is important for those employers who try to notify and keep their employees aware of benefits that are entitled. Also of interest to us personally, of course, is the payment of $1,400 to most individuals, along with the same amount for each dependent. Checks are arriving in bank accounts, and just be aware this is another part of the Biden tax or Biden COVID recovery program. We still have Cal OSHA emergency temporary standards, and you should know that federal OSHA is coming out with new emergency regulations, which will likely appear like the Cal OSHA regulations FedOSHA is not a quick moving organization, so it's possible that we won't see their regulations until the end of April. And whatever they do, if it's more stringent than California, we'll need to amend California's regulations. But Cal-OSHA is now on an aggressive inspection process for employers. And we know some of our clients have not prepared a written COVID plan. You have to not only have it, but have it on the premises to show an inspector when they arrive. These current emergency standards from Cal-OSHA are in effect until June, but quite likely will be extended. And I don't know how to guess how long they would be extended, but it would be likely they'll be extended at least through September of 2021, or maybe as long as into 2023. I don't have any way of knowing what the final ruling on that will be. Under the emergency regulations, just as a reminder, a COVID case is someone who's tested positive or diagnosed with workplace as a source of the COVID. So that's an important concept to be aware of. If someone is a COVID case, then you need to notify people in the workplace of the exposure, and exposure is defined as being within 6 feet of someone with a positive test for more than 15 minutes. And wearing a mask is not an excuse. That does not prevent there from being an exposure. Some companies have had outbreaks. We know that. None of our clients have had an outbreak of more than 20 that I know of, but we've had several employers that have had outbreaks of more than 3 people within a 14-day period, which requires notice to the local Department of Public Health and a notice to your employees offering that they be tested if they've been exposed. The public health departments have been very cooperative, and I don't know of any concerns other than just be aware you need to notify them. And there's a $10,000 penalty if you don't, so it's no reason not to notify them. And you'll need to provide COVID testing to all employees at an exposed workplace. The cost of any testing and the time to take the testing is reimbursable by an employer, which is one of the reasons we would suggest you consider voluntarily extending the FFCRA benefit. Some tips from Cal-OSHA on how to have a healthy workplace, and some of you know this is a reminder: to increase outdoor air circulation or improved air filtration. Maintain physical distancing. Require masks of people who are on your property. The exceptions to masks are if you're in a private office with the door closed and you're the only person, or if you're the only person in a motor vehicle driving the motor vehicle. We also suggest you have some way of reporting so that people can tell you if they are ill or are unable to be at work. And the best way is to have some check-in daily where they either answer some questions, check a list to say that they have checked them. This has been around long enough now. Many of us have adapted processes to handle this, but don't take it for granted. You also need to perform a COVID hazard assessment, including involving employees. And we have done this for many clients. We can do this usually within a couple of hours. It's important that you do this. So having an assessment and having a written plan are required. This is just to let you know that Federal OSHA is coming out with a national emphasis program. And that means they will be focusing on Federal OSHA inspectors all over the country. They also are expected to adopt a standard for employers to comply with. Now in California, we have Cal-OSHA, which enforces the law, not FedOSHA. However, California has to be equal to or more stringent than the federal rules. So we need to keep our eye on what Federal OSHA comes out with. Another ruling that you may be aware of, the California Department of Fair Employment and Housing has announced that employers can require employees to receive a COVID vaccination and can require testing. but the employer has to pay for the time and costs. You can't discriminate on the basis of any protected characteristic like older people or people of a certain national origin or certain sex. Why would you want to? Because any person who comes into your property that's ill can infect others. You can provide reasonable accommodation to those who have a disability that prevents them from being vaccinated, or those individuals who have a sincerely held religious belief. But fear of vaccination is not a justification. Fear of vaccination does not prevent them from having the rules applied to them. Now, this is a serious kind of threshold question for each employer. Are you going to require vaccinations? Are you going to encourage vaccinations? Or are you going to just not be involved in the process? But as many of our clients have found with the disruption when someone becomes diagnosed with COVID, the impact on their workplace, plus all the notices and impact on coworkers, it's an important issue for you to decide. It may well be that you decide not to require vaccination, but encourage it somehow. Encouragement can be as simple as a gift card, a day off, or whatever. But this is an important policy decision employers need to think about. Another issue, which has been around for a long time, but not necessarily on everybody's radar screen, is a court decision in Donahue versus AMN. And what this involved was time rounding and the California law requiring meal periods. So just a reminder to those of us who work in this field, California wage and hour laws require for hourly or non-exempt employees, a meal period be given no more than 5 hours after they start work, and it's a 30-minute duty-free meal period, meaning they're free to do what they want. If an employee works 6 hours or less, the employee and employer may waive the meal period, but if they don't, the meal period applies. And of course, you can have a longer meal period, 30 minutes. The second meal period applies if you're working more than 10 hours. You need to have a second 30-minute meal period. It can be waived if people took their first meal period and don't work more than 12 hours. The kicker is premium pay. If an employee misses a meal period, if the employee is not provided with a meal period, now that's the magic words here, they must be paid an additional hour of pay at their regular rate of compensation. This doesn't mean every time people work get a meal period of 29 minutes, you have to pay them an extra hour. But you do have to have company policies that clarify that employees are supposed to take the meal period, should take the meal period. You monitor their time records, and if they're consistently taking less than 30 minutes, you do something about it. In the Donahue case, the employer had a time capturing policy that rounded their time punches to the nearest 10-minute increment, which resulted in some meal periods that were as short as 22 minutes, being rounded up to 20 minutes. The timekeeping software used a drop-down menu after a missed, short, or delayed menu, which prompted employees' options and notified the employer of their pay obligation. But the prompt only applied if you were beyond the time period and didn't adjust for rounding. The law is it's the employer's duty to ensure that it provides employees with a bona fide relief, and it's accurate, and it's 30 minutes. So anything that would allow the possibility of a meal period of less than 30 minutes is a violation of the law and requires payment of the 1 hour of extra pay for that meal period. Rest breaks are also required. This court decision didn't talk about rest breaks. Rest breaks are paid time, so generally people do not punch in and punch out. But just a reminder, if an employee doesn't get their rest break and their meal period in the same day, that's 2 1-hour penalties. The holding said employers may not use time rounding for meal breaks. Now, what that means technically is you could still use time rounding for start of day and end of day time records, but your clock system usually isn't designed like that. And why would you? With digital and other automatic timekeeping systems, there is no practical justification for not paying people what the time records actually reflect. Now, the second piece is records of short meal periods create what's called a rebuttable presumption that you have to pay them the 1 hour pay. That may not be because it's a 28-minute meal period, you have to pay a penalty. It depends on the circumstances. Like, did they choose to come back early on their own? Then there's no penalty. But did you do anything that impeded them or delayed them? Then the penalty can apply. The problem is most employers don't keep that much attention or records on individual choices on meal periods day after day after day. So what you have to do is come up with a process where you're sure you're in compliance and don't leave yourself unable to explain why someone recorded that they worked less than 30 minutes, or frankly didn't record it at all, because not recording isn't a defense. As some of you in the phone call know, employees who leave work and are mad at their former employer bring lawsuits and allege they weren't provided these meal periods or rest periods. And if there's no record, you don't have a good chance to defend those cases. It's hard. So the takeaways: make sure that meal periods are actually tracked in your timekeeping system and that you don't use rounding. Think about policies to notify employees to take timely and meal periods, such as a standard time every day where expected meal periods are to start and to end. That's a help and evidence to say we have this policy, we remind it. Don't have an employer or a supervisor says, well, it's time for lunch, but let's finish this last project before you go. You've now invaded into the 30-minute time period and set yourself up for a penalty. It's better to schedule meal periods well in advance of the end of the 5th hour of work and the 10th hour of work. Use whatever timekeeping system that can help you identify whether a meal period occurred and must be paid, and evaluate your operating practices to make sure you're making sure to provide and encourage meal periods. And of course, if you give more than a 30-minute meal period, that may give you a little leg of room, but I don't know that's legally necessary if you do the other parts. There's another court decision that's just come down, Bernstein versus Virgin America, Inc. And this was a federal lawsuit, but it involved California's Private Attorney General Act. And this is one of the most common threats to our clients and to employers in California of penalties. It's the number one easy claim for former employees to make against their employer. It's that you did something wrong in the wage and hour law. You didn't give them their 10-minute rest break. You didn't give them their 30-minute meal period. You didn't pay overtime. You didn't pay minimum wage. Your pay stub didn't reflect the information required under California law, and so on and so on. This is an area that employers need to be aware of. If you only have 1 or 2 employees, it isn't terrible. But the larger your employee base, the larger this concern, because it essentially authorizes California employees and their lawyers to enforce the labor code as a private attorney general. It creates a civil penalty per employee per pay period of $100 or up to $200. And the state gets 75% of the money, and the employee and their lawyers get 25%, and the lawyers get attorney's fees on top of this. And it's a 1-year statute of limitations. So if you had 50 employees and you paid employees weekly, think about the number of times and exposures you could have for a PAGA violation. The court in Bernstein versus Virgin America applied a reasoning of a 2008 California case that said an employer is not on notice of a labor code violation until they'd been notified in litigation, or otherwise a court or labor commissioner has heightened it. What the difference we're talking about here is the difference between $100 penalty per pay period and $200 per pay period, which again, if you had 50 or 60 employees, becomes a big item. The key takeaways are, this does provide a basis to protect employers from the higher $200 per pay period PAGA penalty. However, it's a federal court decision, and we don't know whether the California courts will follow it. But the reason we're talking about it for you today is be aware of the importance of compliance with these somewhat detailed wage and hour rules under California law. During this pandemic, many people have had employees working from home. And this is a reminder of the California Labor Code that employers must reimburse all necessary expenditures or losses incurred by an employee in direct consequence of the discharge of his duties or his obedience to the directions of the employer. So if people have expenditures to work at home, this can be covered by this labor code. And it's important that you be aware of it. So what are we talking about? It could be furniture they had to buy, internet connections, increased home utilities, filing folders or supplies they used to get from the company. Hopefully this is an issue that you've taken care of and are aware of, but we're just reminding you of this issue. Just a reminder, when people use their cell phone for company business, a court decision that came down in 2014 says employers must pay a reasonable percentage of an employee's cell phone bills when they're required to use their personal cell phone for business. And this is regardless of whether they actually had any extra cost because of the business-related phone call. Now, to deal with this, we often suggest several choices for employers for policy. Either make a small allowance when people use their cell phones so they get so much a month, for example, $5 or $10 allowance, or have a process where they can claim and file an expense reimbursement documenting what their basis of their cost is. Or some employers have simply said you can't use your personal cell phone for business because we have no way of controlling that. If we want you to use a cell phone for business, we'll give you a business cell phone. Now, that isn't always practical either, but we do want you to be unaware. The purpose of today's discussion is just to call this to your attention. If you're going to have a working from home reimbursement policy, we suggest that it be a written agreement or written notice so it's not a surprise. And one of the things is document what the employee already has, because you may need to replace those if they break, such as computer screens break, hard drives go bad, whatever. But you also don't want to leave it open-ended that they can upgrade to the latest game-specific computer system. So you might want to say reimbursement or replacement has to be approved. The other question is what's necessary? Just because they like it doesn't mean that it's necessary to perform business. And how are they going to get it? Are they going to buy it on their own? Are they going to have the company buy it for them? So on. And how do you work out any disputes? So this is a reminder of the things that you should think about when you have employees working from home. Another provision, just to call to your attention, in the past, employees had 6 months to bring a claim of discharge for violation of wage and hour laws, which are the laws under the jurisdiction of the Labor Commissioner. The California law now extends this to a 1-year statute of limitations and also allows for attorney's fees. So I covered an awful lot, but there are a few things I want you to keep on your radar. If you have 100 or more employees, and that does not mean 100 employees in California, that means 100 employees anywhere with some employees in California, you have a duty to report pay data to the Department of Fair Employment by 3/31. This is the same form which contains much of the information that's been on the U.S. Department of Labor EEO-1 form, but not entirely, because there's some additional questions and classification information needed on the California form. We're getting close to March 31. If you have this obligation, we suggest that you get on it now. Some of our team at CalWorks Safety have experience in doing EEO-1 forms and are trained to help you with this California pay report. I will tell you that there's no monetary fine for failure to file the pay data report. However, the department can obtain a court order and make you pay attorney's fees to file the form. So all things considered, this is a good practice and a requirement that you file the form. Also reminding you that COVID-19 has paid sick leave provisions in it in the Cal/OSHA emergency regulation. Many cities are considering what they call hero pay for people who work in food service, drugstores, large grocery stores. Every city has its own variation. And there are now about 15 cities in California, including the city of Irvine, that have adopted some form of this. And it usually requires an extra pay of $4 or $5 an hour for the employees affected. So if you're in those industries or areas, you need to keep aware of what the hero pay ordinances are. And also realize the Cal/OSHA emergency temporary regulations require pay for people for the time getting tested. And if they're excluded from work because of close contact, you must pay them their wage, which is why at the beginning of this program, we said it was important to think about taking advantage of the extension of the FFCRA law. Also, just a reminder, California's Family Leave, or CFRA, California Family Rights Act, which is very close to the same as the federal FMLA, now applies to employers with 5 or more employees. Before this year, it applied only to employers with 50 or more employees. But now it applies to employers with 5 or more, and the California Rights Act is a little more broad than FMLA, so you need to be aware about that and should be looking at including that in your employee policies and handbooks. Also, if you have over 250 employees, or you're in an industry that is required to provide it, you have already missed the March 2nd deadline to file online your OSHA Form 300A summaries. However, you still must post, you still can do it. And we would suggest that if you missed the deadline, you go ahead and file late, because you will not get a fine if you file late. And this is enforced by Cal/OSHA as well as FedOSHA. So there's no place to hide on this. And it just makes sense to do it. We have a team member at Cal/OSHA, at CalWorks Safety, who can help employers file these online reports. You may have done it last year. This is the 2nd year of this law. But if you need help, let us know. Plus, reminder, posting of the summary at different workplaces, if you have 10 or more employees, is supposed to be up between February 1 and April 30th. So kind of in summary, what all this means is accurate timekeeping and attendance keeping is becoming critically important. It's important to update your timekeeping systems and policies to track meal periods and other requirements, because the penalty of 1 hour's pay a day can be a significant burden. You also need to look at your business reimbursement policies and track COVID-related laws, because these are changing frequently. I have here, and this is hard to read on the screen, but we can send you a copy of the PowerPoint. There's a lot of data, and the law firm of Littler has done a wonderful job accumulating information. So they have information on local leave ordinances, on a survey of what people are doing for return to work, vaccinations, how to handle FedOSHA compliance, and so on. So this is just to tell you they have a lot of resources that are available to you. Ways that CalWorks Safety and HR can help you. Because of the ways in which you can get an unexpected private attorney general claim, it makes sense to us that you would conduct a periodic HR audit of your operations to identify any areas of compliance and get them into constructive compliance so that you protect the company. It's also important to review and update your employee handbook and policies. There are other changes that I haven't discussed today that will affect 2021. It's important that you conduct a COVID inspection and prepare a written COVID plan. And we've done this for hundreds of employers now and are available to help you do these steps if you would like. Another thing that we would suggest you put on your radar screen is to interview employees to find out what their levels of interest or concerns are. This can be levels of engagement or whether they're likely to continue to work for you, or if they have unreported discrimination or harassment claims. Witness what's going on with Governor Cuomo in New York. You don't want to be surprised or blindsided by things that you could have learned if you had simply asked the employees what their concerns or feelings are. It may be having an outsider comes in and makes it easier to conduct these interviews, which could be in person, could be by telephone, could be virtually. It's something to think about. Also, don't forget, provide training. Many companies didn't get the sexual harassment training of all employees of 1 hour and supervisors of 2 hours done by December 31, 2020. It's not too late to do the training. You haven't been cited for it. You haven't been caught on it. Get the training under your belt and with your employees. There's a lot of other safety training and supervisory skill training that we also have available to help you be successful and profitable. We're here to help you. Check our website, give us a call. And with that, Jake, we'll turn it over for questions.
All right, just a couple questions. First one here. We had a guy take the day off on Tuesday to get his vaccine. He's already been paid his full 80 hours of FFCRA leave. Do we pay him for that day?
Well, you have to pay him for the time he needed to take the action. It may not be, I would ask why he had to take a whole day. Now, I have no idea the circumstances, but the time taken is reimbursable, and it's not part of FFCRA. It's a requirement of Cal OSHA regs. But you can use the FFCRA to get reimbursement if you have that in place.
And another question. I created a COVID vaccine incentive effective 3/4/21, giving up to an additional 8 paid sick hours for obtain or recover from vaccine side effects if proof was provided. Now that the FFCRA EPSL has been extended effective, should I terminate the incentive or keep it in place so that employees that already received the extra PSL day don't receive more paid days, that someone that isn't eligible to receive the vaccine yet hasn't been able to get an appointment yet?
Well, let's face it, there's been a difficulty in getting vaccinations, and it's slowly easing up. And just recently, in many areas, they started making available vaccination for food-related workers, for the retail drug and grocery store employees, and so on. This is going to change rapidly in the next 3 to 4 weeks. And I'm not sure whether we'll get to everybody can just call up and schedule a vaccination by May 1st. I hope we can. But I think that I would say I wouldn't do anything to deter vaccinations if you decided not to have a mandatory vaccination policy. It's only to the benefit of the company that people get vaccinated. You avoid the problems of whether it's work-related and a potential workers' comp claim. You avoid the disruptions of people missing work and infecting others. So that's really more practical than legal advice.
What if you received PPP funds? How does this play into the FFCRA and double dipping?
Okay, this is where I confess that I'm not a tax expert in how the PPE loans and the qualifications for reimbursement apply. So I suggest you talk to your banker or your tax advisor on that issue, because uh, that's an area that's very unique and also depends entirely on the circumstances. So I'm declaim responsibility for advice on PPE loans.
All right. And do we have any more questions?
I just want to end up by saying that we have begun the practice of having these, what we call Third Thursday webinars every month. And the next one will be April 15th. Now, the good news is you may have time to participate on April 15th because it looks like the IRS is extending the time for reporting your tax returns until May. I don't know whether the California Franchise Tax Board will do the same thing for California, but likely they will. But I hope that you'll plan to participate on April 15th for our next session. And also send us an email or message about topics that you would like to see covered by these programs, because this only works if it talks about topics that help you. Thank
Right,
you very much.
Thank you, Don, for sharing. Remember, if we didn't address your question today, go ahead and reach out to us. As a reminder, CalWorks Safety and HR is dedicated to helping businesses remain compliant and successful during the COVID-19 pandemic. If you are interested in CalWorks Safety and HR helping you create a COVID-19 workplace prevention policy for your company, please let us know. You can also email us at info@calworksafetyhr.com with any questions you have in the future. Again, be on the lookout for future topics on our website. Thank you. Stay safe, healthy, and have a wonderful day.